What do you do if the arbitration tribunal is constituted when a Section 9 petition is already being heard in court? That is the question that we're going to be talking about today. Hi everyone, my name is Ramana Reddy and I'm a practicing lawyer in the High Court of Telangana. On this channel, I help you by simplifying complex arbitration concepts. For tips, tricks and general legal information, make sure you hit the subscribe button below. So let's take an example. I think that will clarify the issue. Let's say that you enter into an agreement with an artist to buy a painting. Let's say on January 1st, you find out that the artist is planning to sell the painting to a third party without your consent. Now, let's say that the contract that you signed with the artist before January 1st also has an arbitration clause. So what do? On January 5th, you approach the Section 9 court and you say, look, on January 1st, I found out that the painter is trying to sell the painting to a third party. So please prevent him from selling the painting. Now, you file it on the 5th. From January 10th to 20th, the arguments are going on in court, right? Now, let's say that on January 15th, but that is between the 10th and 20th, the arbitration tribunal is constituted, which means an arbitrator is appointed and the arguments are already happening in the Section 9 court. In such a situation, what do? Do you move the proceedings, or do you stop everything that has happened in the Section 9 court and do you move before the arbitrator? Or do you continue things before the Section 9 court, take an order and only then go before the arbitrator? This is the subject matter actually of an interesting case that came up before the Supreme Court recently. I'll post the link in the description below. So the Supreme Court basically said that, look, if the Section 9 court has applied its mind to the particular case, then in such a situation, even if the arbitrator has been appointed before the Section 9 court has passed a judgment, then in such a situation, the Section 9 court can proceed to pass a judgment. It doesn't have to just stop everything just simply because an arbitrator has been appointed. The reason, the rationale behind this, because it's under Section 9(3) of the Arbitration and Conciliation Act, the Supreme Court has said that once a court has entertained the petition under Section 9, then in such a situation, it does not have to stop simply because an arbitrator has been appointed. It can proceed and give a judgment or whatever. It can proceed and give a final order in the Section 9 case. And then with that order, the parties can move before the arbitrator. Now, what does it mean for a court to have entertained a petition? The Supreme Court says that if a Section 9 court has applied its mind, then in such a situation, that means that the court has entertained the petition. And therefore, the parties don't have to just rush to the arbitrator simply because an arbitrator has been appointed. They can close up the arguments before the Section 9 court, take an order, and only then move to the arbitrator. So just to reiterate or to come back to our example, let's say that on January 1st, you find out that the painter is trying to sell the painting to somebody else. On January 5th, you approach the Section 9 court. From January 10th to January 28th, arguments go on. In between that, on January 15th, if an arbitrator is appointed, since arguments have started on January 10th, from January 10th onwards, you don't have to stop everything once the arbitrator is appointed on January 15th. You can wait till January 20th, take an order to the Section 9 court, and then you can move to the arbitrator. I hope that video was helpful. For more information, make sure you click the link below.